They called it a robot lawyer, and their claims suggested that it's capable of performing legal services equivalent to a human lawyer. And it always goes back to any advertising claim in any context should be truthful, substantiated, and fair. So if you're going to say something about AI, you know that that carries power.
Welcome to AI Council Code. I'm your host, Maggie Welsh, and I'm with Julie Albert today, and we're talking about AI washing. So stay tuned for some interesting insights.
Baker Botts, LLP, provides podcasts for educational purposes only. They are not legal advice and are not intended to establish an attorney client relationship. This communication may constitute attorney advertising.
Okay, and we're back, and we have Julie Albert, who's been here on the podcast a number of times now and may need no introduction. But Julie, why don't you just introduce yourself for the listeners and say hi?
Hi again, Maggie. Julie Albert from our brand advertising and copyright group here at Baker Bots, talking about an issue that is near and dear to my heart and top of mind for many clients. This is AI washing.
So to start off, Julie, what is AI washing? How would you define it?
So there isn't a specific definition, but it's a term that is derived from greenwashing, whitewashing, deliberately trying to conceal something unpleasant with something superficial and nice to look at. Typically, for any of these washing type acts in the advertising context, it means being misleading or deceptive in how you market something. And for AI washing, that is how you are talking about AI and trying to get consumers to purchase your product or service.
And why are we talking about AI washing now? How is it different than how companies normally think about marketing their product?
I think it's unquestionable that AI is here to stay, that consumers are interested in it, and marketers know that mentioning AI and talking about AI capabilities in your offerings, AI's value add, that's something that will bring eyeballs and in some cases can drive purchases. So, over the past year or so, through both presidential administrations in recent past, we've seen real agency interest in policing against AI related claims. They're seeing the uptick in people talking about it and want to make sure that people are talking about AI in a responsible way. So, we've seen both the SEC and the FTC take action about what they've characterized as deceptive AI claims. So, on the SEC side, last January, the SEC's Office of Investor Education and Advocacy joined another organization, the North American Securities Administrators Association and FINRA, and they all jointly issued an investor alert on this. That was on fraud involving the purported use of AI in product offerings. The alert covered a whole bunch of topics, but it's really telling that the first sections focused on AI washing, claims about using AI or being leaders in developing or using AI. We've seen an uptick on the FTC side as well. They've recently announced what they are calling a crackdown on deceptive AI claims and schemes. And just as recently as last year, issuing press releases about actions against operations that, and I quote, use AI hype or sell AI technology that can be used in deceptive and unfair ways. They even gave it a cool name. They're calling it Operation AI Comply.
Is that mostly where we're seeing them from, or is it from competitors in the field that are raising these issues as well?
We're seeing it in a variety of forums. So, like any advertising cause of action, there can be agency directed action that would be under the SEC Act or the authority of the FTC Act. We've seen federal and state litigation under the Lanham Act and state law equivalents, and there are administrative forums available. For example, pretty recently, the FTC moved a district court in Arizona for a temporary restraining order against a company called Air AI. And in that case, they've alleged that Air AI made deceptive claims about business growth, earnings potential, and refund guarantees of its conversational AI flagship features. So, just trying to make clear to consumers that when companies are mentioning AI and AI features, that they need to be able to back up those claims with substantiation, just like any advertising claim. We also see a lot of action in these industry self regulatory organizations like the NAD. It's the National Advertising Division of BBB National Programs. So the NAD can independently investigate claims, and it can be a forum for competitor versus competitor challenges. Recently, the NAD instituted some claims by some of the country's biggest tech companies. And a lot of those investigated claims, the ones that they challenged as AI washing or inadequately substantiated, they've been discontinued. So, with that background, I don't think it would be unprecedented or unexpected for competitors to start paying attention and challenge AI related claims before the NAD.
You mentioned greenwashing earlier. What are the parallels between AI washing and greenwashing? And is there anything we can learn from how greenwashing was regulated and enforced in the past?
So, greenwashing became a phenomenon that not only were people using it in advertising claims, saying everything was green and eco friendly and safe and recyclable and healthy and go on and on. We saw the FTC take some pretty directed action, including creating and releasing back in 2012, it feels like 100 years ago, the Green Guides, which are still in place today. Those green guides provide advertisers, consumers, courts, anyone interested in this area of law or this area of practice with guidance on what is deceptive in the environmental marketing context. At the moment, we have not seen that kind of uniform, directed, targeted guidance pulled together for AI washing. I think it's safe to say that those general principles from the Green Guides, things about making generalized claims, about making sure everything you've got is substantiated with data commensurate with the claim that you're making, that those same fundamental principles apply. But we haven't seen that same kind of deep dive for AI washing yet. If we're seeing again the same kind of groundswell that we saw in, we'll call them dubious environmental claims, if we see the same proliferation in the AI context that could happen. But I wouldn't hold my breath waiting for official guidance before paying attention to what you are saying about AI claims in your marketing.
So, could you give our listeners an example of AI washing to help contextualize what they should be looking out for?
Of course, for any advertising claim, the context always matters. So, saying that one kind of claim is problematic is hard to do in a vacuum. You have to look at who is it directed to, what is the product, what are the specific facts, are there any disclaimers, disclosures. But I found one example that could be close to our hearts as lawyers, and that's coming from one of the FTC's earliest enforcement actions on AI. In a complaint against a company called Do Not Pay, the FTC challenged that company's claims of offering consumers an AI lawyer. They called it a robot lawyer, and their claims suggested that it's capable of performing legal services equivalent to a human lawyer, and of course, much cheaper. The company's website advertised that if you use that service, you can, quote, fight corporations, beat bureaucracy, and sue anyone at the press of a button. So the FTC filed the complaint and explained how it viewed those claims as deceptive and misleading. The complaint noted that the company relied on third party LLMs, that it hadn't been trained on comprehensive federal and state laws, regulations, decisions, and applications of law of facts, things that you might remember, Maggie, from law school and our day to day practice of law that we have to stay on top of and be trained on. They pointed out that the company hadn't employed or retained attorneys. In short, the FTC's position was that the express or implied representation that the quote robot lawyer could replace a human lawyer, that representation was false and unsubstantiated. There was a final settlement order that issued in that case earlier this year requiring Do Not Pay to pay just about $200,000 in monetary relief. They had to notify affected consumers, and they're prohibited from advertising that their service performs like a real lawyer unless it has sufficient evidence to back it up. It always goes back to, and we've talked about this before, that any advertising claim in any context should be truthful, substantiated, and fair. So if you're going to say something about AI, you know that that carries power. You know that carries cachet in the eyes of consumers. So as the settlement order in the do not pay matter made clear, of course they can talk about AI and talk about the actual AI capabilities of its service. And if that service does perform like a real lawyer, if they have sufficient evidence to back it up, they would be able to make those truthful claims. But you've got to keep an eye on the evidence.
That's helpful framework to think about, and I think, like you mentioned, a lot of listeners are really excited about AI and wanna share how they're using AI and market it to prospective customers. So, how should companies be thinking about marketing their AI capabilities without drawing allegations of potential AI washing or regulatory scrutiny?
As we were talking about in the do not pay context, but also from the very beginning of our conversation, is AI matters to consumers. They're paying attention. It really does and can add value to companies' service offerings. And innovative AI related products and services are exciting, valuable, and something that marketers shouldn't be afraid to talk about. That was a phenomenon we saw as a reaction to the rise in greenwashing litigation over the past decade. And that reaction got another snazzy term, green hushing, where people who were doing great work in the environmental context were paralyzed, afraid to talk about it for fear of being sued or accused of greenwashing. Think about those claims. It's not about not making them, it's about making them truthfully. Is what you're saying true? If the answer is an unqualified yes, that's great. If it's anything but an unqualified yes for any advertising claim, take a beat and think about whether any changes can be made. Is it substantiated? What do you have to back it up? And if you can't back it up yet, maybe pull together that information, take a look at the claim again, and wait to make it until you have the support for the claim that you want to make. And then the last, and this is the washing phenomenon of, is it fair? Is there something about what you're doing or saying that maybe isn't reflecting the big picture, the context matters of what you're trying to say? Are you overstating the role of AI or its impact? If that's the case, perhaps you can dial it back. But if you are accurately reflecting the services that you're offering, if you've got what you need to back it up, and if you're presenting it in a context that's helpful to your prospective consumer base and not deceptive, bring on the AI.
Awesome. Great insights as always, Julie. Thank you for being with us, and thank you for our listeners for listening to the AI Council Code. Stay tuned for additional podcasts and more insights on AI legal issues from Baker Botts.
Thank you for listening to this Baker Bots podcast. Baker Bots has the experience, knowledge, and people to address our clients' most significant legal issues. For more information on Baker Bots practices, please visit us at bakerbots.com. This presentation is provided by Baker Bots LLP for educational and informational purposes only. It is not legal advice and is not intended to establish an attorney-client relationship. Under the rules of certain jurisdictions, this communication may constitute attorney advertising.